Hello friends, welcome to Sriram's. The topic for today's discussion is Contempt of Court. Senior Advocate of Supreme Court has been held guilty of criminal contempt and the sentence will be based on hearings to be conducted next week. What is Contempt of Court? Contempt refers to the offence of showing disrespect to the dignity or authority of a court. What is the difference between civil and criminal contempt? The Contempt of Court Act 1971 divides contempt into civil and criminal contempt. Civil contempt refers to the willful disobedience to any judgment or willful breach of an undertaking given to the court. Criminal contempt includes any act or publication which scandalizes the court or prejudices any judicial proceeding or interferes with the administration of justice in any other manner. Scandalizing the court broadly refers to the statements or publications which have the effect of undermining public confidence in the judiciary. It is clear that criminal contempt damages the position of judiciary in the eyes of the public. What is the source of judicial powers to punish contempt? Article 129 and 215 of the Constitution of India gives power to the Supreme Court and the High Courts to punish people for their respective contempt. The Contempt of Courts Act of 1971 was made to give it flesh. Article 129 gives power to the apex court to punish contempt shown to the court itself. It means that there is no conflict of interest and denial of justice if the court becomes a judge in its own case. If contempt is shown to subordinate courts or the tribunals, it is either the Supreme Court or the High Court that take up the case. What form can the punishment take? For criminal contempt, it is fine and jail. What is the basis for the punishment of contempt of court? It is to ensure that there is rule of law. Also, it deters disobedience to law. It instills fear about the defiance of law. Without the power to enforce, there is no meaning to power. Legitimacy of judiciary is crucial for democratic stability. Unlike other public figures, judges have no proper forum in which to reply to their criticisms. They cannot debate the issue in public without jeopardizing their impartiality. This is why protection should be given to judges. What safeguards are available for the accused? He can produce truth as evidence for his comments, or show that he acted in good faith. Fair and accurate report of judicial proceeding is not contempt. Fair criticism of judicial ruling on merit is also not contempt. Are the contempt provisions relevant anymore? What is the global comparison? The justification for the provisions to continue comes from a high number of civil and criminal contempt cases pending in various high courts and the Supreme Court. Without the penal powers of court, the judicial edifice may crumble. The offence of scandalizing the court is dropped in United Kingdom as there are no such cases. Further, the offence of scandalizing the court continues to be punishable in UK under other laws. What is the criticism of contempt powers? Right to criticize should be protected, and public institutions in a free society must stand upon their own merits. Well, that's all for today. I hope you enjoyed today's podcast.